Tonight, we revisit a case that appears mostly in the footnotes of Victorian crime history, rather than in its headlines. One woman, one proven conviction, and a series of suspicious deaths that were never brought before a jury. The case of Catherine Wilson begins in the fen country of Lincolnshire, in the early years of the reign of Queen Victoria. Lincolnshire in this period was a predominantly agricultural county, its low flat landscape given over to arable farming, sheep grazing, and the drainage schemes that had reclaimed the fens over the preceding 2 centuries. The market towns of Boston and Spalding served as commercial centres for the surrounding farmland, with weekly markets, modest populations numbering in the low thousands, and a social structure in which domestic service was a common form of employment for unmarried women. Households of even modest means frequently employed a housekeeper, a nurse, or a general servant, particularly where an elderly or infirm family member required day-to-day care. Medicine in this period operated without the regulatory structures that would later govern the nursing profession. There was no licensing body, no standard course of training, and no register of qualified practitioners. A woman could present herself to a household as an experienced nurse on the strength of her own word alone, and in many cases, no further verification was sought or available. It was within this setting, and within this largely unregulated occupation, that Catherine Wilson began the pattern of conduct that would eventually bring her to the Old Bailey. The documentary record concerning Catherine Wilson's early life is sparse. Her birth year is given variously as 1813 and as approximately 1822 across surviving sources, and her birthplace is recorded inconsistently as Boston, Skirbeck, Surfleet, or Waplode, all villages and parishes within a few miles of one another in the Boston and South Holland districts of Lincolnshire. No baptismal record has been conclusively matched to her, with certainty sufficient to resolve the discrepancy. The record is similarly silent on the identity of her parents, on her education, and on the circumstances of her upbringing. What can be established with confidence is that by her early 30s, Wilson was working in the vicinity of Boston in a domestic capacity, taking positions as a housekeeper or nurse within private households. This occupation placed her in direct and sustained contact with the elderly, the infirm, and the recently bereaved, a population that would come to figure repeatedly across the years that followed. Some accounts describe a relationship, and possibly a marriage, between Wilson and a man surnamed Dixon, though his first name is not consistently recorded, and his precise relationship to Wilson is disputed among the sources that discuss him. He is described in some accounts as her husband. In at least one account, he is instead described as a nephew of a woman named Anne Atkinson, who would later come to figure among those associated with Wilson's suspected activities. The nature of the connection between Wilson and Dixon cannot be resolved from the surviving record with certainty, and the details that follow concerning him should be understood as carrying that qualification. If stories like this are ones you find valuable, preserved through court records, testimony, and the documents that survive them, consider liking this video and subscribing to the channel, and let me know in the comments where you are watching from. This story begins in an ordinary household, much like countless others across the fen country of Lincolnshire. The pattern that would eventually be associated with Catherine Wilson's name began to take shape during the middle years of the 1850s, and it followed a consistent structure across the cases in which she was later implicated. Wilson would enter a household as a paid nurse or housekeeper, typically to an elderly patient, a widow, or an individual suffering from a chronic ailment such as gout. She would remain in the household for a period of weeks or months, during which she generally gained the trust and, in several accounts, the personal or romantic attachment of the person under her care. In more than one instance, this trust culminated in the patient altering a will, a promissory note, or another financial instrument in Wilson's favour, sometimes shortly before that patient's death. The pattern recurred across households in Lincolnshire, in the Westmoreland market town of Kirkby Lonsdale, and later in London, over a period spanning roughly 8 years. The first case associated with this pattern concerns a man named Peter Muir, a retired mariner referred to in some records by the honorific captain, for whom Wilson worked in a domestic capacity in the vicinity of Boston. Muir suffered from gout, a condition for which colchicum, an extract derived from the autumn crocus, was a recognised and legitimately prescribed treatment in this period. Colchicum was understood by physicians of the era to be effective in reducing the inflammation associated with gout, and it was also understood to be dangerous in excessive doses, producing symptoms of severe gastrointestinal distress that could, in sufficient quantity, prove fatal. Muir died in 1854. At the time, his death was recorded as an accidental overdose of his own prescribed medication, a conclusion that was not challenged during the period immediately following his death. His body would later be exhumed in 1862, following Wilson's arrest on an unrelated matter, and re-examined by medical authorities for evidence of poisoning. That later examination found no definitive traces of poison in the remains, a result that was expected given the extended interval since death and the chemical properties of colchicum, which degrades over time and was not reliably detectable through the toxicological methods available in this period. Muir's death, in consequence, was never established as murder through any formal medical or legal proceeding. The record does not establish with certainty the nature of Wilson's relationship to Muir beyond her employment as his housekeeper. Some accounts describe a closer personal attachment between the two, though this description does not appear consistently across the available sources and is treated here with appropriate caution. The man surnamed Dixon, whose relationship to Wilson remains disputed in the surviving record, died in London in 1856. A bottle associated with colchicum was reportedly found in his room following his death, and his final illness was marked by violent vomiting consistent with the symptoms associated with colchicum poisoning. The attending physician at the time recommended that a post-mortem examination be conducted. According to the record, Wilson discouraged this recommendation, and no post-mortem examination was in fact performed. In the absence of any medical examination of the body at the time of death, and given that the body was not later exhumed for this specific case, Dixon's death was never subjected to formal toxicological scrutiny, and no charge was ever brought in connection with it. A further case associated with the pattern concerns a woman referred to in the record as Mrs. Jackson, for whom Wilson provided care in the vicinity of Boston. Mrs. Jackson died in 1859 following a sudden illness, approximately 4 days after its onset. Following her death, a sum of money, reported inconsistently across sources as between £120 and £200, was found to be missing from her husband's account. Wilson was subsequently investigated in connection with this death and was brought to trial on a charge relating to it in April of 1862. She was acquitted, the prosecution having been unable to establish sufficient evidence of poison in the absence of a definitive toxicological finding. A further death associated with Wilson concerns Anne Atkinson, a woman who operated a millinery business in the Westmoreland market town of Kirkby Lonsdale, employing apprentice staff in the conduct of that business. Atkinson died while under Wilson's care during a visit to London, at a date recorded inconsistently across sources as either October of 1859 or October of 1860. Her final illness, like those of Moore and Mrs. Jackson, was marked by several days of vomiting and gastrointestinal distress prior to death. Atkinson's body was exhumed in April of 1861, and the subsequent examination reportedly found traces of poison, though at least one source identifies the substance as arsenic, a finding inconsistent with the colchicum method associated with Wilson's other suspected cases. This inconsistency has not been resolved in the surviving record. No formal charge was ever brought against Wilson in connection with Atkinson's death, though the presiding judge at Wilson's later murder trial would remark, in the course of his summing up, that he entertained no doubt as to her responsibility for it. That remark was made in the course of judicial commentary and did not constitute, and was not intended to constitute, a verdict on the matter. By the close of the 1850s, then, Wilson had moved through 3 counties and had come to be associated, in the record later compiled following her arrest, with at least 4 deaths among those for whom she had provided care, in addition to a pattern in which financial arrangements were altered in her favour shortly before each death occurred. None of these 4 cases had, by this point, resulted in a criminal charge, still less a conviction. The pattern would continue into the early 1860s, culminating in the case that would finally bring Wilson before the Central Criminal Court. By the early months of 1862, Wilson had relocated to London, taking a position as a nurse to a woman named Maria Soames, who resided in the vicinity of Bedford Square. Soames had engaged Wilson in a domestic and nursing capacity, and over the course of Wilson's residence in the household, a will was drawn up naming Wilson as a beneficiary, along with a promissory note reported in some accounts to be in the amount of £10. The circumstances surrounding the promissory note are not fully documented, and at least one account suggests it may have been forged, though this detail is single-sourced and is presented here with that qualification. Soames died on the 18th of October, 1856, following an illness characterised by the same pattern of gastrointestinal distress recorded in Wilson's other suspected cases. At the time, her death did not immediately attract suspicion sufficient to prompt a criminal investigation, and it was not until several years later, following events involving a different patient entirely, that the case of Maria Soames would be reopened. That different patient was a woman named Sarah Carnell, for whom Wilson provided nursing care in London in early 1862. The exact date and location of the incidents that followed are recorded inconsistently across sources, with one account placing it in February of 1862 in the district of Marylebone, and another placing it in the district of Kennington. According to the record, Wilson administered to Carnell a liquid represented as a soothing draught, intended, according to Wilson's own words, as later reported, to warm her. The liquid was, in fact, sulphuric acid. Carnell tasted the substance, experienced an immediate burning sensation, and spat it out before swallowing a significant quantity. The portion of the liquid that spilled during the incident burned through the fabric of the bedclothes on which it fell, a detail entered into the subsequent record as physical evidence of the causticity of the substance involved. Carnell survived the incident. Wilson departed London in its immediate aftermath and remained at large for a period of approximately 6 weeks before being apprehended. Carnell's survival and her subsequent report of the incident to the authorities marks the point at which the pattern of suspicious deaths associated with Wilson first came under formal and sustained investigation. Prior to this point, each of the earlier deaths, those of Peter Marr, of the man surnamed Dixon, of Mrs. Jackson, and of Anne Atkinson, had been treated individually and without any connecting inquiry. Following Wilson's arrest, investigators began the process of reviewing these earlier deaths collectively, a process that required the exhumation of remains that had, in some cases, been buried for several years. The investigation into Wilson's activities was not conducted through the kind of centralised detective inquiry that would characterise later criminal investigations of this type. The available record does not name specific investigating officers, nor does it describe a formal Metropolitan Police investigation of the kind later associated with more prominent Victorian murder cases. Instead, the process appears to have proceeded through the ordinary mechanisms of magistrates' committal proceedings, grand jury consideration, and the exhumation of remains for medical re-examination, mechanisms that were standard for the period, but that are not documented in the kind of procedural detail available for later, more thoroughly recorded cases. Statements were taken from those who had known Wilson's various patients, and from members of the households in which she had worked, though the specific content of these statements is not preserved in the sources available for this account. The exhumations proceeded across the early months of 1862. Anne Atkinson's remains were exhumed in April of 1861, a date that, if accurate, would place this particular exhumation prior to the Carnell incident, suggesting that some degree of suspicion regarding Wilson may already have been forming before the events of early 1862 brought matters to a head. Peter Moore's remains and those of Maria Soames were exhumed later in 1862, following Wilson's arrest on the Carnell matter and the reopening of the Soames case. The medical examination of Maria Soames's remains was conducted by Alfred Swain Taylor, Professor of Medical Jurisprudence at Guy's Hospital and the most prominent forensic toxicologist working in England during this period. Taylor had previously given evidence in the trial of William Palmer, the so-called Rugeley poisoner, some 6 years earlier, and his standing in matters of forensic toxicology was well established by the time he was called upon to examine Soames's remains. Taylor's report, dated the 29th of July, 1862, according to the surviving record, found no definitive traces of mineral poison in the remains. This absence was consistent with the properties of colchicum, an organic alkaloid rather than a metallic compound, of the kind more readily detected through the toxicological methods available at the time, and one that would in any case have substantially degraded over the period between Soames's death and the exhumation of her remains. Taylor's evidence rested instead on the clinical symptoms recorded at the time of Soames's death, namely the severe abdominal pain, vomiting, and diarrhea consistent with colchicum poisoning, rather than on a direct chemical finding. Taylor's examination of Peter Moore's remains, conducted in the same period, found no poison traces whatsoever, a result that left Moore's death without any forensic confirmation of foul play. The examination of Anne Atkinson's remains reportedly identified traces of poison, though the specific substance identified, given in at least one source as arsenic, sits uneasily alongside the colchicum method associated with Wilson's other suspected cases, and this discrepancy has not been resolved in the available record. These findings were entered into the official record as the basis upon which Wilson would ultimately be brought to trial for the murder of Maria Soames alone. The deaths of Mere, of Dixon and of Atkinson, together with the case involving Mrs. Jackson, remained matters of suspicion rather than of proven fact, a distinction that the proceedings which followed did not erase. Wilson was committed to stand trial at the Central Criminal Court, commonly known as the Old Bailey, on two separate matters arising from these investigations. The available record does not describe the specific content of any coroner's inquest convened in connection with Soames's death beyond the general fact that suspicion led to exhumation, medical examination, and eventual committal for trial, and this account accordingly does not attempt to reconstruct inquest proceedings beyond what the record supports. The investigation, taken as a whole, had by the late summer of 1862 produced two formal charges against Catherine Wilson, one concerning the attempted murder of Sarah Carnell, and one concerning the murder of Maria Soames. The four earlier deaths remained, and would remain, outside the reach of any formal charge. The proceedings that followed would test the first of these two charges before the second was brought to trial. The first trial, concerning the attempted murder of Sarah Carnell by sulfuric acid, commenced at the Central Criminal Court in 1862. The presiding judges recorded inconsistently across the available sources, named in some as Baron Bramwell, and in others as Lord Chief Baron Pollock, a discrepancy that has not been resolved and that this account does not attempt to settle by asserting either name with confidence. Wilson's defence in this trial was conducted by Montague Williams, who would later be appointed Queen's Counsel and who would go on to represent Wilson again in the trial that followed. Williams argued that the sulfuric acid had been supplied to Wilson in error by a chemist's assistant, who had provided the caustic substance in place of the medicine that had actually been intended for Carnell's treatment. This account rested on the premise of an innocent mistake in the preparation of medication, rather than on any denial that the substance administered to Carnell had in fact been sulfuric acid. The jury returned a verdict of not guilty on the charge concerning Sarah Carnell, notwithstanding accounts suggesting that the presiding judge had signalled a measure of scepticism toward the defence's account during his summing up of the evidence. Wilson was acquitted and left the dock a free woman with respect to this particular charge. She did not remain free for long. Immediately upon leaving the dock, Wilson was rearrested on a separate charge, this one concerning the murder of Maria Soames. The mechanism by which this second arrest was carried out is not described in detail in the available sources, though the general practice of executing a separate charge upon a defendant, regardless of an acquittal on an unrelated matter, was standard legal procedure for the period, and no irregularity in this respect is suggested anywhere in the record. The acquittal on the Carnell charge, followed within moments by rearrest on the Soames charge, marked the transition from the first phase of Wilson's legal proceedings to the second. The record shows no interval between the two matters. What followed would be the trial, upon which Catherine Wilson's place in the historical record would ultimately rest. The trial for the murder of Maria Soames commenced at the Old Bailey on the 25th of September, 1862. The presiding judge was Mr. Justice John Barnard Byles, a detail that is consistently corroborated across the available sources without contradiction. Montague Williams again conducted Wilson's defence, as he had in the Carnell matter. The identity of the prosecuting counsel in this trial is not recorded in any of the sources consulted for this account, and this account, accordingly, does not attempt to name one. The prosecution's case against Wilson rested upon three principal strands of evidence. The first concerned the alteration of Maria Soames's will and the associated promissory note in Wilson's favour entered into evidence as demonstrating a financial motive consistent with the pattern observed across Wilson's other suspected cases. The second concerned the medical evidence provided by Alfred Swain Taylor, whose testimony established the clinical symptoms of Soames's final illness as consistent with colchicum poisoning, notwithstanding the absence of a definitive chemical finding of poison in the exhumed remains. The third concerned the broader pattern of conduct associated with Wilson across her previous positions, though the deaths of Moore, Dixon and Atkinson, and the case involving Mrs. Jackson, were not entered as separate charges within this particular trial, and were referenced where they were referenced at all, only as background to the character of the conduct alleged against her. Taylor's testimony before the court described in detail the symptoms recorded at the time of Soames's death, the severe abdominal pain, the vomiting, and the diarrhea that had preceded her final collapse, and set these symptoms alongside the known clinical effects of colchicum poisoning as understood by medical science of the period. He testified further to the difficulty inherent in detecting colchicine, the active alkaloid within colchicum, in remains that had been interred for a considerable period prior to exhumation, explaining to the court that the absence of a positive chemical finding did not, in his professional opinion, undermine the conclusion that poisoning by colchicum had in fact occurred. The defence conducted by Montague Williams challenged the sufficiency of this medical evidence directly. Williams argued to the jury that colchicine could not be reliably detected in human remains after the interval of time that had elapsed between Soames's death and the exhumation of her body, and that the prosecution's case therefore rested on an inference from symptoms, rather than on any conclusive chemical demonstration that poison had been present. This argument reflected a genuine limitation of the toxicological science available in this period. Colchicine lacked, and would continue to lack for more than a century afterward, a simple and universally reliable method of post-mortem detection, a limitation that would not be substantially addressed until the development of more advanced chemical analysis methods in the 20th century. Williams's argument on this point was, in consequence, not merely a rhetorical strategy, but a reflection of an authentic evidentiary weakness in the prosecution's case. The jury nonetheless heard the totality of the evidence presented, weighing Taylor's clinical testimony, the financial circumstances surrounding the alteration of Soames's will, and the account of Soames's final illness given by those who had attended her in her final days. The jury retired to consider its verdict, and after a period reported in one source as approximately 2 hours, though this detail carries only moderate confidence given its reliance on a single account, the jury returned to deliver its finding. The jury returned a verdict of guilty of willful murder. The verdict was entered in the record of the Central Criminal Court on the 25th of September, 1862. The prosecution's case, resting substantially on symptomatic rather than direct chemical evidence, had been accepted by the jury as sufficient to establish Wilson's guilt beyond reasonable doubt. The conviction concerned the death of Maria Soames alone. It did not extend to, and did not purport to resolve, the deaths of Peter Moore, of the man surnamed Dixon, of Mrs. Jackson, or of Anne Atkinson, each of which remained, at the conclusion of this trial, a matter of suspicion rather than of legal fact. The court proceeded to sentencing following the return of the verdict. Mr. Justice Byles addressed the court prior to pronouncing sentence, and is reported, according to a single source not independently corroborated by a verbatim transcript, to have stated that he had never encountered a case more clearly proved, and that the pain and suffering endured by the victim had been observed with considerable deliberation by the person responsible for inflicting it. The precise wording of this remark cannot be verified against a primary trial transcript, and it is presented here with that qualification. Wilson was condemned to death, the sentence prescribed by law for a conviction of willful murder in this period. A further remark, attributed to Mr. Justice Byles, has entered into the record surrounding this case, though its provenance differs substantially from the sentencing remarks described above. According to Montague Williams' own memoir, published in 1890 under the title Leaves of a Life, Byles privately remarked to Williams, following the conclusion of the trial, that he had prosecuted a man named Rush for the murder of a Mr. Jermy, had defended a man named Daniel Good, and had defended several other notable criminals during his time on the Norfolk circuit, but that, in his opinion, Williams had that day defended the greatest criminal that had ever lived. This remark, often repeated in later accounts of the case, is sourced exclusively to Williams' memoir, published some 28 years after the trial concluded, and represents a private recollection offered by the defence barrister himself, rather than any statement entered into the official court record. It is presented here, according to that provenance, as a recollection attributed to Wilson's own defence counsel, rather than as a verified courtroom statement. The available record does not describe any petition for clemency submitted on Wilson's behalf, nor any appeal to the Home Office seeking commutation of her sentence. This absence may reflect either the fact that no such petition or appeal was made, or the possibility that any such record has not survived in a form accessible to this account. No detail concerning the volume or character of press coverage following the trial has been located in the sources consulted, beyond the general fact that her execution drew a substantial public crowd, a matter addressed below. The trial and sentencing of Catherine Wilson concluded the legal proceedings against her. The verdict of guilty and the sentence of death that followed it would stand as the only judicially established fact among the several deaths with which her name had come to be associated. Wilson was executed on Monday, the 20th of October, 1862, at Newgate Prison in London. The executioner was William Calcraft, who served in this capacity at Newgate for much of the mid-Victorian period, and whose name recurs across numerous executions carried out at the prison during these decades. The execution was conducted in public, in keeping with the practice that would continue in England for a further 6 years, until the passage of legislation ending public executions following the hanging of Michael Barrett at Newgate in May of 1868. Accounts of the crowd gathered to witness Wilson's execution describe a dense mass of spectators extending from Smithfield to Ludgate Hill, with a number of those present reported to have waited through the night and through rain in order to secure a position from which to observe the proceedings. The figure most commonly repeated across secondary accounts places the crowd at approximately 20,000 persons, though this figure has not been traced to a specific contemporary newspaper report in the course of this research and should accordingly be understood as a widely repeated estimate from the period rather than a precisely verified count. Accounts of Wilson's demeanour upon the scaffold differ substantially from one source to another, and the discrepancy cannot be resolved from the material available. One account describes her as maintaining a claim of innocence to the end, ascending the scaffold with little visible display of emotion and dying without visible struggle. A separate account describes her demeanour instead as cool, sneering, and indifferent, without any sign of repentance for the crime of which she had been convicted. These two characterizations cannot be reconciled, and both are presented here as they appear in the surviving record, with the contradiction between them left unresolved rather than settled in favour of either account. Following her execution, Wilson's body was buried within the precincts of the jail, a practice standard for executed prisoners at Newgate and elsewhere in England during this period. The execution of Catherine Wilson concluded the formal proceedings arising from her case. She had been tried for one murder, convicted, and executed. The deaths of Peter Marr, of the man surnamed Dixon, of Mrs. Jackson, and of Anne Atkinson remained at the time of her execution, and thereafter matters of suspicion that no subsequent legal proceeding would ever resolve. The years immediately following Wilson's execution produced a modest cultural response, typical of high-profile Newgate hangings of the period. Printed broadsides commemorating her case were sold among the crowds gathered for the execution, and in the days that followed, a practice common to public executions throughout the era. Surviving examples of these broadsides, held today among collections of Victorian crime ephemera, carry titles describing the life, trial, confession, and execution of Catherine Wilson, the female poisoner, for the murder of Mrs. Soames. These broadsides represent the principal artefacts of Wilson's case to survive from the period immediately surrounding her death. Beyond these broadsides, Wilson's case did not generate the kind of sustained cultural attention that attached to some of her contemporaries. No novel stage play or dedicated modern examination of her case in isolation has been identified in the course of this research. The fullest surviving account of her trial from a participant's perspective remains Montague Williams's 1890 memoir, Leaves of a Life, written by the barrister who had conducted her defence in both of her trials. Williams' account, offered nearly 3 decades after the events it describes, stands as a personal recollection rather than a formal legal record, and it is presented in the historical memory of this case with that distinction preserved. Catherine Wilson's case occupies a particular place within the broader record of Victorian criminal history. She is remembered, where she is remembered at all, primarily within specialist accounts of 19th century poisoning cases, appearing alongside other figures whose crimes exploited positions of domestic and medical trust during this period. She has not attained the sustained cultural prominence of some of her contemporaries, whose cases produced dramatic adaptations, popular ballads, or lasting associations in British cultural memory. Her case instead survives principally within the documentary record, in the broadsides sold at the time of her execution, and in the memoir of the barrister who defended her. One distinction attaching to Wilson's case carries a degree of historical significance. She is documented with reasonable, though not entirely conclusive sourcing, as the last woman publicly hanged specifically within London. This distinction is narrower than a claim to being the last woman publicly hanged in England, or in Britain as a whole, a distinction that instead belongs to a woman named Frances Kidder, hanged at Maidstone, Kent, in April of 1868, shortly before the practice of public execution was ended altogether in England following the hanging of Michael Barrett at Newgate the following month. Women executed in the intervening years between Wilson's death and Kidder's, including cases in Chester and Exeter, were carried out at locations outside London, a pattern that lends support to the narrower claim concerning Wilson without extending to the broader one. Wilson's case is further notable for the period in which it occurred, situated at the very beginning of the professionalisation of nursing in England. Florence Nightingale's training school for nurses opened at St Thomas Hospital in 1860, a date falling within the very years of Wilson's suspected offending, which is generally understood to have begun around 1854 and continued until her arrest in 1862. Prior to this reform, private nursing carried no requirement of formal training, licensing, or vetting of any kind, and a woman could present herself to a household as an experienced nurse without any means by which that household could verify her claim. Wilson's case, considered within this context, illustrates a period in which the domestic and medical trust extended to a private nurse rested entirely upon the word of the person claiming that role, with no institutional safeguards standing behind it. The regulatory environment surrounding poisons during this period offers a further point of context relevant to Wilson's case. The Sale of Arsenic Regulation Act of 1851 had been passed in response to a wave of arsenic poisoning cases during the preceding decades, requiring the maintenance of poison registers and the dyeing of arsenic sold for non-medicinal purposes. Colchicum, the substance associated with Wilson's suspected method, fell outside the specific reach of this legislation, being a legitimately prescribed medical treatment for gout rather than a substance subject to the same restrictions as arsenic. Wilson's case, considered alongside this regulatory history, illustrates a pattern in which the tightening of restrictions around one poison, arsenic, corresponded with an increasing reliance among those who sought to poison undetected upon substances that remained outside the reach of equivalent regulation. The autumn crocus from which colchicum was derived, known botanically as Colchicum autumnale, grew commonly across English meadowland and had been employed in the treatment of gouty conditions since the early years of the 19th century, following its introduction into conventional medical practice by physicians who had observed its effect upon the inflammation associated with the condition. It was typically prepared as a tincture or a wine, administered in small and carefully measured doses, with physicians of the period well aware that the margin between a therapeutic dose and a dangerous one was narrow. A patient already prescribed colchicum for gout, as Peter Moore had been, presented a particular vulnerability to this method, since an increased dose administered by a trusted nurse would not, in itself, arouse suspicion in a household accustomed to the medicine's regular use. The apparent legitimacy of the substance in the sick room was, in this respect, central to the pattern later associated with Wilson's conduct. The households in which Wilson took up positions during these years were not uniform in their character. Peter Mawer's household in the vicinity of Boston was that of a man who had spent his working life at sea and had returned to Lincolnshire in his later years, a common pattern among retired mariners of the period who settled in the market towns and villages nearest to the ports from which they had sailed. Anne Atkinson's household in Kirkby Lonsdale was of a different character entirely. Atkinson operated her own millinery business in the town, employing apprentice staff in the manufacture and sale of hats and related goods, a position that reflected a degree of independent trade uncommon among women of the period, but not unheard of in the small market towns of Westmoreland, where women frequently ran shops dealing in millinery, drapery, and similar goods. Atkinson's business gave her a measure of financial standing that made her, in the pattern later associated with Wilson, a plausible target for the kind of arrangement in which trust was gained and a testamentary benefit secured before illness intervened. The process by which the earlier deaths came to be re-examined following Wilson's arrest in 1862 required more than the simple issuing of an order. Exhumation in this period was carried out under authority granted by the Home Office or by a coroner and involved the physical disinterment of a coffin that had, in the case of Anne Atkinson, lain in the ground for close to a year, and in the case of Peter Moore, considerably longer. The remains were then transported under conditions intended to preserve whatever evidence might remain to a location where a qualified examiner could conduct a thorough post-mortem analysis. Alfred Swain Taylor's involvement in this process placed him at the centre of an examination that required not merely a visual inspection of the remains, but a chemical analysis intended to detect the presence of colchicine, a substance that presented particular difficulty for the toxicological methods of the period, given its organic composition and its tendency to degrade over time within buried remains. Taylor's laboratory work in this period relied upon extraction and testing methods that had been developed principally for the detection of metallic poisons such as arsenic and antimony, methods considerably less suited to an alkaloid poison of this kind. The absence of a positive chemical finding in several of these cases reflected, in substantial part, this limitation in the available science, rather than necessarily indicating the absence of poison at the time of death. The interviews conducted with those who had known Wilson's patients formed a further part of the investigative process that preceded her committal for trial. Members of the households in which she had worked, neighbours, and in some instances the surviving relatives of the deceased, were asked to give accounts of the final illnesses they had witnessed, of the symptoms observed, and of their recollection of Wilson's conduct during the period of her employment. These accounts, taken collectively, established the recurring pattern of sudden and severe gastrointestinal illness that preceded each of the deaths later associated with Wilson, a pattern that, considered case by case, might have been attributed to natural causes, but that, considered together across 5 or more instances over a period of 8 years, presented a different picture entirely to those responsible for compiling the case against her. The period between Wilson's conviction on the 25th of September 1862 and her execution on the 20th of October of the same year spanned approximately 3.5 weeks, a period during which she was held within Newgate Prison under sentence of death. Prisoners under sentence of death in this period were typically held in a condemned cell separate from the general prison population, attended by a chaplain whose role included preparing the condemned individual for execution through religious instruction and, where the prisoner was willing, confession. The available record does not describe in detail the content of any religious ministrations Wilson received during this period, nor does it document any statement of confession attributed to her prior to her execution, beyond the account already noted of her maintaining a claim of innocence according to at least one version of the events surrounding her death. The morning of the 20th of October 1862 followed the established procedure for a public execution at Newgate during this period. The condemned prisoner was brought from the condemned cell to the scaffold erected outside the prison in view of the assembled crowd, accompanied by the prison chaplain and by the officials responsible for overseeing the execution. William Calcraft, in his capacity as executioner, would have made the necessary preparations upon the scaffold itself, a role he performed at Newgate across several decades of the mid-Victorian period, presiding over the executions of numerous individuals convicted of capital offences during these years. The crowd gathered for Wilson's execution, estimated in the widely repeated figure of 20,000 persons, would have included among its number those who had travelled considerable distances to witness the hanging of a woman whose case had attracted the particular attention reserved for crimes involving poison, a method of killing that carried in the public imagination of the period a distinct character of calculation and concealment, differing from crimes of sudden violence in the degree of premeditation it was understood to require. The broadsides sold among this crowd, and in the days following the execution, followed a well-established format common to Newgate executions throughout the period. Such broadsides typically combined a brief account of the crime and trial with a purported statement or confession attributed to the condemned prisoner. Verses composed in a moralizing tone intended to draw a lesson from the case for the broader public, and in some instances a woodcut illustration depicting the scaffold or the crowd. These productions were sold cheaply, intended for a mass audience gathered specifically for the occasion of the execution, and their content did not necessarily reflect verified fact so much as the conventions of a genre intended to satisfy public curiosity and to reinforce, through moral commentary, the consequences of the crime for which the execution was being carried out. Surviving examples of the broadsides associated with Wilson's case follow this pattern, presenting her life and crimes in a manner consistent with the broader tradition of execution literature, current in England throughout the middle decades of the 19th century. The professionalisation of nursing that began in earnest with the opening of Florence Nightingale's training school in 1860 did not proceed swiftly enough to have altered the conditions under which Wilson had operated during the preceding 6 years, and its early effects would not have been felt broadly across private domestic nursing arrangements for a considerable period afterward. The school established at St Thomas Hospital represented an early and limited effort at formal training, producing a small number of certified nurses in its initial years, while the great majority of private nursing positions across England continued to be filled, as they had been throughout Wilson's career, by women whose qualifications rested entirely upon their own representation of prior experience. A household seeking to engage a nurse for an elderly or ailing family member during this period had no register, no certifying body, and no institutional mechanism by which to verify the claims made by an applicant for such a position. This absence of any structure of verification stood at the centre of the vulnerability that Wilson's case, considered as a whole, illustrated across each of the households in which she came to work. The legal mechanism by which a testator's will could be altered in this period, governed by the Wills Act of 1837, required that the document be signed by the testator and witnessed by two persons present together at the time of signing. These formalities existed as a safeguard against precisely the kind of undue influence later associated with Wilson's conduct, requiring witnesses whose presence might, in principle, have provided some check against a will altered under circumstances of pressure or manipulation exercised by a caregiver over a vulnerable patient. The available record does not describe in detail how Wilson navigated these witnessing requirements in the specific instances associated with her case, though the pattern of testamentary alteration attributed to her across multiple households suggests that the formal safeguards established by the Act did not, in practice, prevent the arrangements from proceeding as she intended. The chemist's shop from which Sarah Carnell's sulfuric acid was said to have originated operated as any number of similar establishments did across London during this period, dispensing both medicines prepared according to physicians' prescriptions and household preparations sold over the counter for general use. Sulfuric acid itself was not, in this period, a substance restricted to specialised or licensed sale in the manner that would later govern the distribution of dangerous chemicals. It found ordinary use in a range of domestic and trade applications, from the cleaning of metal surfaces to certain preparations used in dyeing and in other small manufacturing processes, and its presence upon the shelves of a chemist's establishment, whether intended for sale to tradesmen or for use in compounding other preparations, would not itself have been considered unusual. The defence argument advanced by Montague Williams at Wilson's first trial, that the acid had reached her hands through an error on the part of a chemist's assistant rather than through any deliberate acquisition on her own part, rested upon this ordinary availability of the substance and upon the plausibility that a mistake of this kind could occur amid the routine business of a busy chemist's shop. Sarah Carnell's own circumstances at the time she engaged Wilson's services as a nurse are not extensively documented in the sources available for this account, beyond the fact that she resided within London and required nursing care sufficient to warrant the engagement of a live-in attendant. The moment described in the surviving record, in which Wilson offered Carnell a liquid represented as a preparation intended to provide comfort and warmth, and in which Carnell tasted the substance before recognising its causticity and spitting it from her mouth, represents one of the few incidents within the entirety of Wilson's suspected career for which a surviving account exists of the moment of administration itself, rather than merely its aftermath. In each of the earlier cases associated with Wilson, the only surviving testimony concerned the symptoms that followed administration of whatever substance had been given, since in each of those instances the patient did not survive to describe the moment at which the substance was administered. Carnell's survival and her consequent ability to describe the incident directly distinguishes her case within the broader pattern and accounts for the particular significance her testimony carried in bringing Wilson's conduct to the attention of the authorities. Following the incident, Wilson did not remain within the household to attend to its aftermath, but instead departed London, a period of absence that extended to approximately 6 weeks before her eventual apprehension. The record does not describe in detail the means by which she supported herself during this period, nor the specific location or locations to which she travelled, though the interval itself indicates a deliberate effort to avoid the authorities following an incident that, unlike her patient's deaths, had produced a surviving witness capable of directly implicating her in an act of poisoning. The trial that followed Wilson's return to London and her committal on the Carnell charge took place within the courtroom of the Central Criminal Court, a chamber that by the middle years of the 19th century had witnessed a long succession of England's most closely followed criminal proceedings. The public gallery of the Old Bailey during a trial of this character would typically have been filled to capacity, the case having already attracted a measure of public attention on account of the unusual nature of the alleged attempt, an assault by caustic acid administered under the guise of a medicinal preparation, a method distinct from the poisoning by ingestion associated with Wilson's other suspected victims. Reporters representing the London press would have occupied a designated portion of the courtroom, recording the proceedings for publication in the days following the trial, a standard practice for cases of this prominence during the period. The witnesses called in the course of the Carnell trial would have included Carnell herself, describing under oath the circumstances of the incident and the sensations she experienced upon tasting the liquid given to her, together with any medical practitioner called upon to examine her injuries and to testify as to the corrosive effect of the substance involved. The specific content of this testimony, beyond the general facts already established in the surviving accounts of the case, is not preserved in the sources consulted for this account, and this narrative does not attempt to reconstruct dialogue or testimony beyond what the record supports. The acquittal returned in this first trial, followed within moments by Wilson's rearrest on the separate charge concerning Maria Soames, would have unfolded within the same courtroom, and before much the same assembly of spectators and reporters who had followed the Carnell proceedings to their conclusion. The immediacy of the second arrest occurring as Wilson stepped from the dock, a free woman with respect to the charge just decided, represented, within the practice of the period, an entirely regular exercise of the authorities' power to proceed upon a separate indictment, notwithstanding the outcome of the matter just concluded. For those observing from the gallery, the sequence would have presented an unusual spectacle, an acquittal immediately followed by a fresh committal, though the legal mechanism underlying it was unremarkable within the ordinary practice of English criminal procedure. The trial that followed, concerning the murder of Maria Soames, proceeded before Mr. Justice Byles across the days surrounding the 25th of September, 1862. The courtroom in which this second trial unfolded would have been furnished according to the standard arrangement of the period, the judge's bench positioned to command a view of the dock in which the accused stood, counsel for the prosecution and the defence arranged at tables before the bench, and the jury of 12 men seated to one side, drawn according to the practice of the period from among the property-holding men of the district eligible for jury service, under the qualifications then in force. Montague Williams, in mounting Wilson's defence, had by this stage in his career established himself as a barrister of growing reputation within the criminal courts of London, a reputation that would continue to develop in the years following Wilson's trial, and that would eventually see him appointed to the rank of Queen's Counsel. His defence of Wilson across both of her trials represented, within the broader arc of his career, one of the more prominent instances of his practice during this period, and his own later account of the case, offered within his 1890 memoir, reflects the impression that his defence of Wilson had left upon him some 3 decades afterward. The jury's deliberation upon the charge concerning Maria Soames required the weighing of evidence that combined, on the one hand, medical testimony resting on symptomatic inference rather than direct chemical proof, and on the other, evidence of financial arrangements and testamentary alteration that spoke to motive rather than to the mechanism of death itself. The combination of these 2 strands, considered together with whatever account was offered of the pattern of Wilson's prior conduct, evidently proved sufficient to satisfy the 12 men of the jury that her guilt had been established beyond reasonable doubt, notwithstanding the absence of the kind of direct chemical finding that later toxicological science would have been able to supply. The distinction between the outcome of Wilson's 2 trials, an acquittal in the matter of Sarah Carnell and a conviction in the matter of Maria Soames, reflects a difference in the character of the evidence available in each case rather than any difference in the underlying conduct alleged. In the Carnell matter, the defence's account of an innocent mistake in the compounding of medicine offered the jury a plausible alternative explanation consistent with Carnell's survival and with the absence of any established prior arrangement between Wilson and Carnell of the kind alleged in the Soames case. In the Soames matter, by contrast, the combination of testamentary benefit and consistent clinical symptomatology left less room for an innocent explanation, and the jury's verdict reflected that distinction. The financial dimension of the case involving Anne Atkinson carried its own distinct complication, since Atkinson's estate, upon her death, would ordinarily have passed under the control of her husband, Joseph Atkinson, in keeping with the legal principle then governing married women's property, under which a wife's assets during marriage were understood in law to belong to her husband, rather than to her independently. This principle, which would not be substantially altered until the passage of reforming legislation in 1870, and again in 1882, meant that any arrangement Wilson may have sought to establish in connection with Atkinson's millinery business or her personal estate would necessarily have required navigating an interest already vested in Joseph Atkinson, rather than dealing solely with Anne Atkinson as an independent party. The available record does not describe in detail how or whether Wilson attempted to establish a financial benefit in connection with this particular case, and this account accordingly does not assert one. The apprentices employed within Anne Atkinson's millinery business in Kirkby Lonsdale would, in the ordinary course of a household and business of this kind, have had occasion to observe Wilson's presence and conduct during the period of her employment there, whether as a nurse attending to Atkinson directly, or in some more general domestic capacity within the household. The surviving record does not preserve any statement attributed to these apprentices concerning their observations of Wilson, and no testimony from them is recorded as having been given in connection with the later proceedings against her, a gap in the documentary record that leaves this portion of Wilson's activities in Kirkby Lonsdale less thoroughly illuminated than the events surrounding her later years in London. The town of Kirkby Lonsdale itself, situated within the historic county of Westmoreland along the River Lune, presented in this period a character considerably different from the fen country of Lincolnshire, in which Wilson had begun her career, or from the metropolis of London, in which it would end. Westmoreland, in the mid-19th century, remained a sparsely populated county, its economy centred upon sheep farming across its upland districts, and upon the small trades and shops that served the surrounding agricultural population within its market towns. Kirkby Lonsdale itself functioned as one such market centre, its weekly market and its modest population of shopkeepers and tradespeople providing the setting within which a business, such as Anne Atkinson's millinery shop, could establish itself and draw custom from the surrounding farms and villages. Wilson's presence within this setting following her earlier years in Lincolnshire, illustrates the mobility that her occupation as a nurse and housekeeper afforded her, a mobility that placed her successively within 3 quite different regional settings across the span of less than a decade. London, the final setting of Wilson's suspected career, presented by contrast a scale and anonymity considerably beyond anything available to her in either Lincolnshire or Westmoreland. By the 1850s and early 1860s, London had grown to a population exceeding 2 million persons, its districts ranging from the fashionable squares of Bloomsbury, in which Bedford Square and the household of Maria Soames were situated, to the more modest streets of Kennington and Marylebone, in which Sarah Carnell's household is variously placed according to the conflicting accounts of that incident. A woman moving between positions of domestic service within a city of this size faced considerably less risk of her reputation preceding her from one household to the next than would have been the case within the smaller and more closely acquainted communities of Boston or Kirkby Lonsdale, a circumstance that may account, in part, for the concentration of Wilson's later suspected activity within the capital rather than within the smaller towns where her career had begun. The unresolved status of the 4 earlier deaths associated with Wilson's name, those of Peter Marwer, of the man surnamed Dixon, of Mrs. Jackson and of Anne Atkinson, left the families and associates of each without the resolution that a formal conviction might have provided. Marwer's exhumation in 1862 produced no finding of poison, closing, in effect, any prospect that his death would be judicially reconsidered. The absence of any post-mortem examination of Dixon at the time of his death foreclosed, from the outset, the possibility of a later toxicological finding of the kind obtained in Soames's case, since no exhumation of Dixon's remains is recorded as having been undertaken. Mrs. Jackson's case proceeded to trial and concluded in acquittal, a result that left the missing funds from her husband's account unaccounted for within any judicial finding. Anne Atkinson's case, despite the disputed finding of poison upon exhumation and the extrajudicial remark offered by Mr. Justice Byles during his summing up in the Soames trial, never itself proceeded to a formal charge, leaving her husband, Joseph Atkinson, and whatever family she may have had, without the judicial determination that a trial would have provided. The broader pattern that emerges from these 4 unresolved cases, considered alongside the single conviction obtained in the matter of Maria Soames, illustrates a recurring difficulty within 19th century poisoning prosecutions generally, namely the reliance of the prosecution upon toxicological methods capable of detecting certain classes of poison, principally the metallic poisons such as arsenic, while remaining considerably less capable of establishing the presence of organic alkaloid poisons such as colchicine with the same degree of chemical certainty. This limitation, well understood by forensic practitioners of the period, including Alfred Swain Taylor himself, meant that a poisoner employing a substance such as colchicum retained a measure of practical protection against detection that a poisoner employing arsenic did not possess to nearly the same degree, particularly following the tightening of arsenic sales under the 1851 Act. Wilson's case, considered in this light, illustrates both the particular vulnerability of colchicum as an undetected method of poisoning during this period and the practical limits that this vulnerability placed upon the capacity of the investigating and prosecuting authorities to establish guilt in cases beyond the one in which a conviction was ultimately secured. The development of forensic toxicology in the decades following Wilson's execution would gradually address some of these limitations, as chemical analysis methods improved and as the medical understanding of alkaloid poisons such as colchicine advanced beyond the state of knowledge available to Taylor and his contemporaries in 1862. These developments, however, arose principally from the broader progress of forensic science across the second half of the 19th century, rather than from any specific reform traceable directly to Wilson's case, which is not documented in the available sources as having prompted any particular change in law, in toxicological practice or in the regulation of medicines, such as colchicum. The case remained in this respect a demonstration of an existing limitation rather than a catalyst for its correction. The case of Catherine Wilson closes the record of this examination. She was tried once for one murder among several she was suspected of having committed, and was convicted and executed on that single charge. The verdict was entered in the record of the Central Criminal Court. It has remained there. The verdict stood. The case became part of British memory.